So we talk about the general principles governing the duties of a director. And one of the principles is that a director need not exhibit a greater degree of skill that may be more than reasonable from a person of his knowledge and experience. For example, a director of a life insurance company does not guarantee that he has the skill of an actuary or a physician. So when you appoint a director, the skills that he has need not be an expert. He may be appointed director as a managing director of a group of hospitals, but that does not mean that he needs also to be a specialist in whichever area of medicine. No, he just needs to have the requisite skills and abilities to do his job. The element of expertise is not an issue here. You just need to be qualified for the job. You need not be an expert in that field, that company, which you are appointed a director to. And a director must exercise reasonable care and diligence. But errors of judgment, in this case of Brazilian rubber plantations, it was said that a director's duty has been laid down as requiring him to act with such care as is reasonably to be expected from him, having regard to his knowledge and experience. He is, I think, not bound to bring any special qualification to his office. He may undertake the management of a company in complete ignorance of everything connected with rubber, without incurring responsibility for the mistakes that may result from such ignorance. And if he is acquainted with the rubber business, he must give the company the advantage of his knowledge when transacting the company's business. This is what we are saying. If you're appointed as a managing director or any other director in a group of hospitals, your qualifications would be that you are a qualified accountant, probably with a degree to boot. You may not need to be a doctor in order to be that managing director or any director in that board that you represent the company from. But should you be a medical doctor and you come with that expertise, that you are a doctor of, you are a cardiologist, 10 years experience, then it is expected you will use those skills in your position to negotiate better. You know better because you are directly linked with that job. But you, with your professional qualification, your degree in business, your master's in business, you're only supposed to exercise due diligence and care. You need not be an expert in the medical field. And if you're not an expert and something happens, you cannot be held responsible for that. We also talk about a director must exercise reasonable care and diligence, but is not liable for errors of judgment. And we talk of the reasonable care and diligence of an ordinary man. And this is what we are saying of you with your capabilities, not you as an expert, not you as going way beyond the bare minimum of the qualifications that were given. And in Lagana's nitrate versus Lagana syndicate, Lindley M.R. observed directors are their powers, and if they act with such care as is reasonably expected from them, having regard to their knowledge and experiences, and if they act honestly for the benefit of the company they represent, they discharge both their equitable as well as their legal to the company. We talk of reasonable care. We talk of honesty. And this is an ordinary person in your capacity as a director. If faced with such an issue, would the decision be the same? And if the decision would be the same, again, having acted honestly, then you are exempted from that liability, both in equity and in law. We also talk about a director may reasonably rely on co-directors and officers of the company. And in determining a director's duties, consideration must be given to the nature of the company's business, and provided that the work is distributed in a reasonable way, to the manner in which the work is distributed between the directors and other officials, then in the absence of grounds of suspicion, the official, if you delegate some of the work to another official, if it's again seen that you did it with due care, due diligence, and with the company's interests at heart, then you are allowed to do that. You may rely on others to also perform your duties. In Dovey versus Corey, in which a bank had sustained heavy losses by the issue of fraudulent balance sheets and the improper advance of money to customers of the bank, the frauds were the work of the manager and the chairman. And the question arose whether a co-director, though in fact innocent of any complicity, was liable to the company for negligence in not having discovered the frauds. The House of Lords, in the result, exonerated him from liability on the ground that the director may properly delegate to trusted subordinates the details of management. And Lord Halsbury said, "It is obvious if there is such a duty, that is of detecting fraud, it must render anything like an intelligent devolution of labor impossible. I cannot think it can be expected of a director that he should be watching either the inferior offices of the bank or verifying the calculations of the auditor himself. The business of life could not go on if people could not trust those who are put in a position of trust for the express purpose of attending to details of management. More or less, you are allowed as a director to rely on others. You are allowed to delegate. And you are allowed to have other people take part in the duties that you normally partake in. That judgment was, a director is not, so to speak, a monitoring spirit, that he needs to be present for any transaction to take place. He needs to be present for any activity. He just does not sit there and watch. He can comfortably delegate, and that such delegations are perfectly in order. We talk of a director having a duty to attend board meetings. You remember when we were talking about meetings, the various types of meeting, they are directors' meetings, and this is where their issues are put in place and the normal nature of business. If this director, again, continuously misses these meetings without due care, without following up, that is seen to be negligence on the part of his failing his duties. And where one is negligent, then disciplinary in the sense that whatever is discussed in these meetings and your absence would have helped prevent a loss, your presence would have helped prevent a loss, your presence would have ensured that you guide others in a better way, then you will be held liable for such absence. And when we say negligence, this is because diligence carries with it the necessity of giving some attention to the company's affairs. You cannot be appointed a director who is never present. You need to ensure that your presence is felt. So this non-attendance is that the director will be guilty of the breaches of trust. And while it is not necessary to attend every board meeting, your presence must be felt in that company. You cannot miss all, just as other issues may arise and you are not able to attend all. And these principles were developed largely in relation to non-executive directors. And today, it's common that directors may hold full-time service agreements with the company, and the service contract may impose obligations that go beyond the duties of a normal director. So where you have a full-time service contract, where there's no other, this is not part-time for you, then your contract may indicate that you devote the whole of your working time to the company. And this is where negligence by non-attendance would be very critical, because if you have a contract, you must abide by the rules of your contract. And section 177 inter alia reads that every company other than a private company registered after the appointed day shall have at least 2 directors, and every company registered before the appointed day and every private company shall have at least 1 director. You see, the Act says at least. It does not fix the number. This is a guideline, bare minimum. This is what should be done. And the purpose of that is to maintain a dual control in the management of the affairs of the company and to prevent fraudulent mechanisms by one-man management. That element of at least, which is 1 or more than 1, so that there is someone keeping track of the other's actions. So how do we appoint directors? 1, we have first directors. And when we talked about the articles of association of a company, when filing them with the Register of Companies, the forms that are presented to the registrar, you have to have the names of the directors with their signatures appended, with their addresses appended on those forms, and these will be presented to the registrar. So the very first directors are normally listed in the Articles of Association, and the promoters usually appoint them. And if there's no provision, then the subscribers to the memorandum are deemed to be the first directors. These first directors normally retire at the first AGM, where the new directors are now elected by the shareholders in accordance with the articles of a company. So the first directors are to comply with the law, that you're going to present the articles of association to the registrar. Part of the articles of the association and the schedules attached are those that require the directors' names and their addresses. So we talk about subsequent directors. You remember the first directors at the first AGM, the shareholders elect the next directors, and these are the subsequent directors. And this is according to Article 89 of Table A. The first AGM, the first annual general meeting, which we said must be held within 18 months of that incorporation of the company. And for every subsequent annual general meeting of the company, the directors will either be re-elected or they will be retired. And at least a third of the total members, the voting for elections, a third must be present. And the directors longest in office shall retire first. If you have served for the articles will provide for how long can you serve, how long can you be re-elected, and when do you now retire. So we have talked about the retirement, and this is where the appointment for casual vacancies may also appear. So where a director is vacated before the expiry of his term, such a casual vacancy may be filled or is an addition to the existing directors. But the total number must not exceed the regulations of the company. They must not exceed the articles of the company. And for these casual vacancies, where we have said a director vacates before their term is over, so whoever fills up his position can only do so up until the next AGM. And the one who has filled the position is eligible for re-election. So his name shall be in that list which will be provided, and he may be re-elected. We talk about the appointment of alternate directors. Again, we talk about the articles authorizing, or if a resolution is passed in a general meeting, then an alternate director shall be appointed, or the board may appoint such an alternate director. This is to cure that element of someone not being always available. For alternate directors, they cannot be full-time contract directors. This is where you have other businesses you attend to, and the nature of your business, and if the articles again provide that you're not always present to oversee the duties, you're not present to confirm the happenings of the company. So an alternate is placed to ensure that there is no vacuum. When you're not there, someone else is acting with the same capabilities that you have. And Section 182 provides the restrictions on appointment, and it reads that a person shall not be capable of being appointed a director of a company and shall not be named as a director or proposed director of a company in a prospectus issued by on behalf of the company in relation to the intended company, or in a statement in lieu of prospectus delivered to the registrar by or on behalf of the company, unless before the registration of the articles or the publication of the prospectus or the delivery of the statement in lieu of the prospectus, as the case may be, by his agent signed and delivered, either signed the memorandum taken from the company and paid or agreed to pay for his qualifications, or signed and delivered an undertaking to pay for his qualification shares, made and delivered to the registrar for registration a statutory declaration to the effect that a number of shares not less than his qualification are registered in his name. And it goes on to say it doesn't apply to a company not having a share capital or a private company and all this. So the Act clearly states these are the restrictions on appointment or advertisement of a director. So unless you follow this, the Act specifically prohibits you from being a director or from being named a director. We talked about the age limit of directors in section 186 of the Companies Act, and section 186 provides that you first need to be between the ages of 21 and 70. So you can't be a director when you're younger than 21 or older than 70. Subsection 2. And it goes on to say that, in accordance with the articles as well. So you read the Act with the articles of association, but the age limit is clear, is provided for in the Act on how old you can be for you to be a director of a public company. And 187 goes on to say that you have a duty to disclose how old are you.